because there are certain notifications issued.
Wait, how these notifications has been issued? This is the question. He cannot. They cannot.
Answer is there.
State cannot.
State has not done it. Central government.
Wait, this finding of the NGT must be adverted to by the state.
Very.
Then you come to Forest Conservation Act 1980. Restriction on the de-reservation of forest or forest of land or non-forest purpose. Section 2 is very clear that notwithstanding anything contained in any other law for the time being, in force in a state, no state government or other authority shall make, except the prior approval of the central government, any order directing. I asked you to issue a notice to say ASG. Where is ASG? No notice was given to him.
Notice down? ASG ke notice dite bolecho. Agir din to bolecho.
Bring notice to the ASG. You did not do anything.
And to that I cannot have any. To that I have no answer.
He has to come.
And I have to take it on me. I take it on my shoulders, but I have not been able to instruct them properly to give this notice.
Mr. Answer, what is your answer?
It will be necessary for direction of the particular district.
Yes, you have to obtain it. That is the exact observation of NGT. Now he is showing some notification from the end of central government. In the absence of central government, how can he take these matters? Yes, where is Mr. Samim, Mr. Vikas Bhattacharya? They are raising issue, shouting every day that let the matter be taken out. At that time, neither of them are available. Are you serious to issue? Are you serious? Neither the applicant, I don't know what is the reason the applicant being totally absent. Whatever he has communicated, put it on affidavit. Put it on affidavit. One cannot say that whatever he wants to bring the things before the court and the court will dance on the fingertips of the applicant. These are the issues, burning issues. And what about the land trashing units? The district magistrate on 26 November 24, non-functional. The particular inspection conducted on 29 July 21 in presence of such and such. This is Mal jointly. During inspection is found stone crusher unit situated very close to the proximity of the liver lady. Where is that? It is not functioning. At the time of the inspection, of course, they will not, in front of your nose, they will do the work. Why didn't you remove all these materials from there? Why didn't you remove this? Because your district magistrate has reported.
Not the competent jurisdiction, but it is the totally depend on.
I don't know who is the authority to remove these things.
District magistrate.
The district magistrate is saying,
The land.
Listen, Mr. Answer, what he has written is very close proximity, distance of 100 feet. It is also found no machineries were operating at the time of visiting. Of course, it will not. And also there was no vehicular movement, transportation of materials to and from the crashing unit. But the crashing unit is there. The undersigned has also like to submit that neither the district magistrate Jalpai nor the ADM Jalpaiguri is authorized to empower to issue consent. Because the ADM says that it was not, no consent was issued from their end. But it was found at the time, Mr. Answer, at the time of inspection, did you expect that they will be crashing these things, they will go in front of your nose? They have simply fled away. If you turn around, then they will go again. So why don't you take steps for removal of these things from the river beds? You did not do anything. If you go there, you may so happen to me, you will be finding they are merely doing these things.
In this regard, your lordship kindly direct to the concerned DM lord related to the land related law. Within 2 weeks or 3 weeks, I will.
Please, Mr. Answer, activate your officers. There are two parts of the NGT order. One is closure of these homestays
Homestay.
and other illegal sand mining. Sorry, not the sand mining, these stone minings. Removal of stones from the river beds. Second part, there is no challenge. So if it has come to your knowledge that some units are still operating, you may not find it functional at the time. But you have the duty to remove all these, seize all these things. Why didn't you do that?
দেখো না ভাই,
Why didn't you do that?
দেখো ওখানে এপিডেভিট লিখে দিয়ে স্টোন আসল ফাংশনই করছে না।
এটা
কোথায়
কি
গিয়েছে?
এ সাধারণ দেখি না
All of you are raising an issue with. Tell me what you want. You want it should continue, then continue. I'm just allowing the repetition. You want to continue. That they should continue.
Direct the concerned district magistrate regarding the stone cracker. As well as the.
may I just say with regard to this
homestay,
crusher, my lord,
there is no objection.
there is a letter dated 10/12/2024. It has been issued by the Chief Conservator of Forest, my lord, wherein it has been mentioned, based on the reports received from the divisional forest officers of the Darjeeling, Kurseong, and Kalimpong forest divisions, this is to certify that from the boundary of river up to 200 meter, there is no crusher unit established on the recorded forest land. This is the
Then what
letter
is
dated.
this? Then what is this?
That is letter, my lord, which date, my lord,
This
that
is
letter?
26 November.
It is December, my lord.
Maybe within 1 month there is
In
nothing.
December,
No
my lord.
trace. 26 December it is found.
That's what, my lord. That's what, my lord. Let everything be on record before his lordship, my lord. Let a direction may be given, my lord. I also, my lord, for the my lord, tourism, let me put on records, my lord, that homestays are not commercially viable, my lord. And why I'll tell to his lordship, my lord, the definition of homestay. No, my lord, my lord. May I say this, my lord?
Two things make clear.
Lordship.
If it is in the forest land, if the restrictions of the Forest Act of Section
No, my lord.
2 comes in, if you convert it in the revenue village without the required central government permission, then it will go.
No, no, why? What is the definition of homestay, my lord? I believe, my lord,
I'm
that
not
has
going into
has
that.
not been taken
I
into
am
consideration
not-
by the tribunal, my lord.
Mr. Bosumollik, I am not on the point. I am only on the point when a forest declared, reserve forest declared, and there is a restriction, even a state cannot convert it into another without the sanction of central government, then I have
Then
to
we'll have
know from the central government whether such permission was, because the tribunal says there is no such permission.
So that is tribunal. I do not know on what basis tribunal had said that.
Yeah,
That's what,
why
my lord,
don't
what
you,
is,
why,
what
why,
is,
the, why the, in the absence of the applicant, in the absence of the central government, I have to decide it.
no, cannot be, cannot be,
Huh?
cannot be,
I have to decide it.
cannot be.
Let the central government come
Yes,
and
but
say,
central comes and say, my lord, we have
say
given the
that we
permission.
have never permitted the state to issue notification to declare a forest land as a revenue village. If it is not, everything goes.
Kindly permit me to add the central government as a party in my petition. In fact, my lord, the central government is not a party.
Made a party,
We'll make
made
them a
party,
party.
issue notice.
Very
And
well.
what kind of notification you want to supply
Yes.
the supplementary affidavit and put whatever has been stated by the applicant Shivas Datta for his absence in this matter.
That he has informed him.
Then that put it.
We'll
put
put
it.
it. we'll
I
put
shall, I can file an affidavit to that effect. But I had a talk with him,
it. বলেছি, দাদা,
I
বলেছি।
understand. Let him not choose not to appear.
and when in my matter, even Union of India is a party. That service was made upon them, they did not appear. Well,
No, you have to seek your, because Mr. Samim, the question is very clear. First of all, prima facie, I was satisfied with Mr. Bhattacharya's argument, but after seeing Rule 5, I think the Constitution prima facie is to be correct. Rule 5 under the NGT rules. Secondly, the observation that if it is conservation, forest conservation 1980 under a reserve forest declared by virtue of section 2 only can be declared, otherwise can be used without the notification of the permission from the central government. That cannot be done. Section 2 of the 1980 Act. So do it, bring central government. The government says, yes, we have given permission.
May I answer
Well,
in two sentences with the leave of my learned friend? Now, please see page 308 of the application. It was brought to the notice that these homestays are outside the sanctuary area. All these villages.
Then-
And Milord, even so far as revenue villages, I have an answer. Milord, please see this.
This is supplementary
Supplementary
evidence.
affidavit affirmed today.
Since in the absence of the applicant, I have to appoint an amicus curiae to assist this court.
কোন রুলসটা ব্যবসা রিলাই করছে সেই রুলসটা কোথায়
Milord, please see.
এনজিটি রুলস
Please see.
This is your tourism, state tourism policy.
No, Milord, please see page 6. Milord, this is dated 8 November 2013.
yes is the first the central government তোমরা কোন গভর্নমেন্ট
What is this?
তোমরা নেই
Milord, this is issued by the government of India Ministry of Tribal Affairs.
What is this?
Milord, conversion of all forest villages, old habitations, unsurveyed villages, etc., into revenue villages under section 318 of the New Tribes and other traditional forest.
Mr. Bhattacharya,
I'm sorry.
converting a revenue-free village under the Scheduled Tribes, Scheduled and other Forest Dwellers Act 2006, my query is not meeting there. A reserve forest declared, what is the power of the state to declare it a revenue-free village? That question has been raised by the revenue-free village. It has been what is the purpose and what is the preamble of this act? To protect the forest dweller means tribals and other forest dwellers. You are not a forest dweller.
Yes, we are forest dwellers.
You have to prove it. You are a forest.
We have been staying there since 1890, some of us. Our forefathers were there.
That suits your case. Now, forest dwelling tribal, then what was the purpose of this act? And what is the query of the court and how the tribunal has reacted? If you want to justify your revenue-free declaration of revenue-free on the basis of it, then you are at liberty. Should I take this supplementary affidavit on record?
To enter into that issue.
Supplementary.
This is your stand regarding revenue.
May I humbly say,
This is your stand regarding.
we did not get
Very
the
well,
opportunity to give the stand before the
Now
tribunal.
it is now. It
Before
is
the
separate.
tribunal, we were not
This
even
is your,
asked. We were not even parties. That is
Mr.
the
Bhattacharya, I'm taking it your supplementary affidavit on record. As this is a stand of yours to justify the forest land converting into a revenue free.
Milord, without meaning any disrespect to my learned esteemed senior Milord, kindly visualize we were not heard. Elementary thing is we should have been heard. Apart from thing, Milord, they have
You want to
very-
rely on it? You want to rely on it?
These are documents.
Ashun.
In the meantime, Lordship, in the meantime,
Milord, I did not make any observations.
Spend
Milord, we will give a copy to the central government.
Take back, think twice. Today,
expand
I
from
have
the-
asked you to consider section 2 of the.
Very well, we'll come.
now that
But
if
in-
we have very
And,
humble prayer if my lord decides independently like, we welcome and that's good but if your lordship my lord relies upon the NGT order
No, your point I understand.
yes,
That
that
is
goes.
reality, but please consult proviso
I
appended to
just want.
section 4
Yes.
of the act vis-a-vis rule 5.
yes I'm reading so
Rule 5.
first of all my lord is well aware that the rule cannot supersede
Of
the
course
statute.
not. It is a
Statute.
rule making power.
Yes, a rule making but to effectuate the statute. Here the statute categorically says that there should be equal number of expert and non-expert. Rule 5 says that the president has a authority to constitute a bench for more than 2.
But first of all, what the
Well, may I read out? As I understand, minimum number of members who shall hear application or appeal. I am talking about rules. I am reading from rules. The tribunal shall hear an application or appeal as the case may be consisting of at least by a judicial and an expert member. Therefore,
you
there
have
is
questioned the constitution of the tribunal itself, that it was no quorum as per
yes.
proviso appended to section 4. Section 4, the entire section 4, subsection 4 of this section
Yes.
is a rule making power.
No.
that-
So kindly come to the section composition of tribunal. Similar the substantial provision. My lord kindly takes this. Rulemaking power is different. Kindly turn to section 4 of the Tribunal Act. National Green Tribunal Act 2010.
This first part is composition of the tribunal.
Tribunal.
Then
this-
subsection for central government may, in consultation with the chairperson of the tribunal, make rules
Yes.
regulating generally or the practices and procedure of the tribunal, including.
Yes.
Therefore, this is a rule-making power vested with the central government to be framed in consultation with the chairperson. The central government has framed the rule.
Yes.
Rule 5 prescribes if there is one member, one judicial member, and minimum one judicial member,
One expert member.
and one expert member, that is sufficient. Now I want to know from you whether this constitution, if we go by the rule, constitution of the present tribunal whose order is under challenge, is right or wrong?
Absolutely wrong. Kindly see the number. Here, my lord, even Rule 5 says that even one expert, one judicial member, the bench may be constituted, maintaining the balance,
Why so not offended?
not offended. There says that equal number of judicial member and expert member. But here it was obvious that the judicial members have outnumbered the expert
Sir,
members.
the applicant is not here.
Applicant, I am told, my lord, that
Then he will not choose not to appear, but I don't know why. Why he is not appearing?
no, here I am told, my lord, he feels subject to correction. Without
That the High Court cannot go into that.
Why should I go to High Court? High Court jurisdiction.
But he can come when there is necessary.
No, that's told me that the execution, if the execution proceedings is going on, if tribunal has passed
He
any
too
order,
has to.
then his
No, but
document may-
Why didn't you, are you appearing for the petitioner?
No, I am not appearing for the petitioner. Only thing.
No, but the
For the tourism department.
Yes.
If you want to, allow everyone.
No.
If it is your policy that the forest, within the forest core area, there will be homestays, hotels, allow it.
No, not hotels. The homestay is different than hotels.
But
completely
here the
different.
tribunal is not consider the
Why-
definition
Are
of.
you shying off the giving notice to the?
No, we shall come. No, but in the meantime, kindly maintain the status quo. Otherwise, but if ultimately,
Can anyone inform Mr. Lokki Gupta? I would like to appoint him as a
yes,
amicus
I will
curiae.
inform you.
Island.
Huh?
I'll
In these
inform.
two matters, he will be assisting this court in the absence of applicant.
Yes.
Just give me, Mr. Bhattacharya, you are too busy. We are not getting assistance of yours. Please give me a date. First week of January.